you're live.
Good afternoon, everyone. Thank you all for joining us. This is the first event in this year's Rising Up for Human Dignity series. This year's series focuses on the nature of justice and repair, centering on the different forms justice can take and the nature of reparation and repair. We're examining the needs and the practices through diverse communities. And the sponsoring organizations for this series and every year's series, we're so happy to have so many partners. The Oregon Jewish Museum and Center for Holocaust Education, PSU's Holocaust and Genocide Studies Project, World Oregon, Oregon Historical Society, Kol Shalom Community for Humanistic Judaism, and my organization, Never Again Coalition. Today's discussion, Prospects for Justice, the U.S. and Atrocity Crimes, will delve into possibilities and limitations of accountability for atrocity crimes through a U.S. lens, examining the options victims of mass atrocities have to seek justice through the U.S. judicial system, what the U.S. policies are for supporting international justice mechanisms in cases of atrocity crimes, and what actually are atrocity crimes. We have two incredible panelists today. They are Kristin Smith, Director of the Atrocity Crimes Initiative, a group of projects focused on atrocity prevention, response and accountability, and jointly supported by the ABA's Criminal Justice Section and the Center for Human Rights. Prior to her work at the American Bar Association, Kristin worked on issues of gender equality, reproductive rights, and justice for sexual and gender-based crimes as a legal fellow at the Global Justice Center. She also previously supported the Whitney R. Harris World Law Institute's international research and educational initiatives as a fellow, and worked prior as a legislative analyst and criminal prosecutor in Oregon for all of our Oregon listeners out there. She's a graduate of the University of Notre Dame and Washington University in St. Louis's School of Law. We also have with us Esti Tambay. She's currently a senior counsel at the International Justice Program at Human Rights Watch, focusing on institutional issues related to the International Criminal Court, the ICC, and U.S. policy toward the court, as well as accountability in several African countries. She previously worked at the Coalition for the ICC, conducted research for the International Center for Transitional Justice in the Democratic Republic of Congo, and worked on several U.S. litigations seeking corporate accountability pursuant to the Alien Tort Statute. For almost a decade, she specialized in international arbitration and complex cross-border litigation. She has also advised the UN Office of Legal Affairs on legal claims raised against the UN. She holds a Bachelor of Arts from Columbia University and a Juris Doctor from Harvard Law. And with us to moderate today, we have Amanda Singer, Director of PSU's Holocaust and Genocide Studies Project, one of our beloved partners in this series. So I'm going to turn it over to Amanda to get us started. Thanks.
Thank you, Lauren, and thank you, panelists, for being part of this, and thank you for participants for your interest in this important topic. I think we're going to just jump in and get started, and I'm going to ask you to put any questions that you have into the Q&A. I will be keeping track of those questions. Amber of the Oregon Jewish Museum and I will be keeping track of questions so that we can be sure to ask them to the panelists at the end during our Q&A. And so to get us started, I'm going to ask Kristin to give us a little bit of background about the terms that are going to be used throughout the session, and that will help us follow along with the presentation. So thank you, Kristin, for getting us started.
Thank you. Yes, happy to do that. And thank you to all the sponsors of this program. I really appreciate the time and the interest of both you and the attendees. So thank you so much for having us. I have a little PowerPoint to get us started. So I'm going to share that. Okay. So I promised to talk about a few things to get the conversation started. First, oh, and I should say, sorry, I always forget just the typical disclaimer that I'm speaking on in my personal capacity today, not necessarily on behalf of the American Bar Association. So back to get us started, I'm going to talk about what are atrocity crimes and make sure we're all on the same page about what those terms mean and highlight some of the differences between those crimes. and then give a kind of 30,000 feet level of what the laws that the US has are on atrocity crimes, criminal, civil, and some other related issues like atrocity prevention. Give a few suggestions, again, in my personal capacity, how they might be strengthened. And then also briefly highlight what kind of groups work to advance justice and accountability in the United States, and maybe just pitch a few ideas about why this topic matters. So to start off, when we talk about atrocity crimes, we're talking about three kind of sets of crimes: genocide, war crimes, and crimes against humanity. And some of those crimes, like in specific circumstances, criminal acts could be all three of those crimes, but they also have distinct differences. So they each have a particular context that they need in order to be considered an atrocity crime. You know, when a murder, for example, rises to the level of a war crime, crime against humanity, or a crime of genocide. And they all have different sources of law and cover unique sets of criminal conduct. So you'll see genocide. The context for that is that it needs to be committed with intent to destroy in whole or apart in a national, ethnical, racial, or religious group. And I think the kind of unique attribute of genocide is that it recognizes the attempt to destroy groups because of their perceived group membership. It's also typically quite difficult to prove in court, just because evidence of that specific intent to destroy isn't always as accessible as prosecutors might think. And then there's some examples of the types of acts that could constitute genocide, and that's pulled from the Genocide Convention. War crimes are necessarily committed in armed conflict, so that's kind of their overall context, and they protect certain persons, both combatants and non-combatants, and civilians and civilian objects from attack, and regulate the way these protected points are treated during war. And some examples are torture, attacking humanitarian assistance, the use of child soldiers, or attacking objects of cultural heritage. And then lastly is crimes against humanity. And the required context for that is that it's a criminal act committed as part of a widespread or systematic attack against a civilian population. Some examples are murder, deportation, sexual violence, persecution, and apartheid. And I think that the key context for crimes against humanity and what makes it unique is that it covers criminal conduct that targets civilians during peacetime. It also can cover crimes committed during war if they're on a widespread or systematic basis, but it also reaches peacetime. So things like post-election violence, persecution of certain groups, arbitrary detention of certain groups, that kind of thing. So, you can see there are specific acts. I gave some examples of how something could be both of those things, but they do also cover sets of distinct criminal conduct. And then in the United States, we have several kinds of laws that cover atrocity crimes. The first type is criminal jurisdiction. And so that means it's in the US criminal code, and means that domestic US courts have jurisdiction over individuals who are suspected of perpetrating those crimes. So we have that over genocide. We have it over the specific crimes of recruitment and use of child soldiers and torture. So those are like specific acts that can be international crimes, but were incorporated into the US criminal code on their own. And then one I wanted to highlight is the US has long had jurisdiction over war crimes, but it had a significant limitation that was recently amended in 2022. So we've actually seen some progress in strengthening domestic US jurisdiction on atrocity crimes. And that was done through the Justice for Victims of War Crimes Act, which expanded US war crimes jurisdiction to include war crimes committed either in the United States or anywhere. So including crimes committed abroad when the perpetrator is found in the United States. And it also eliminated the statute of limitations, which meant that these crimes could be prosecuted, more than 5 years after they occur, for example. So that present in jurisdiction was really a practical hurdle to reaching these types of crimes before. And so that was a big kind of win for victim communities and those interested in seeing the US play a greater role in accountability. There's civil jurisdiction over a limited number and type of atrocities, through the Torture Victims Protection Act and the Alien Tort Statute. So the Torture Victim Protection Act allows, a victim of torture to sue for a tort in US law. So again, not putting somebody in jail, but trying to recoup damages for harm caused to them that is illegal because of our laws on torture. But that has kind of really limited applicability, and it only covers torture and extrajudicial killing. So only victims of those specific crimes can sue their perpetrators in civil court. And the Alien Tort Statute was used to sue, again, in civil court, perpetrators who committed crimes abroad, but it was severely limited over the past kind of decade or so by the Supreme Court, and now is presumed not to apply to crimes committed abroad unless there's a strong connection to the United States, and that hasn't been very successful in the last few cases. So that's another area. And then lastly, there's lots of other legislation that impacts the US's role in atrocity prevention, its support for the International Criminal Court, which my colleague is going to talk about later, and then international justice more broadly. So I just wanted to kind of let you know that those laws exist. One is the Elie Wiesel Genocide and Atrocities Prevention Act, and that sought to institutionalize efforts of atrocity prevention within the US government. So it kind of created in law a mandate for an interagency group across the executive branch, so like the Department of Justice, the State Department, intelligence agencies, to all work together on atrocity prevention and create strategies, identify gaps, and pursue a more holistic atrocity prevention strategy. So that was a really important act in the past few years as well. And then there's, situation-specific legislation that Congress passes from time to time. And there's also legislation on related policy agendas like women, peace, and security. Now, I'm highlighting just a few legal gaps and challenges in using these laws. The first one, and one that I work on quite regularly these days, is that there is no crimes against humanity statute in the United States. So as I noted, we have ones on genocide and war crimes, but there's no crimes against humanity law in domestic US criminal law. So what that means is that if a perpetrator of crimes against humanity is found in the United States, the Department of Justice doesn't have the legal authority necessary to prosecute them for their substantive crimes. So they resort to using things like immigration violations to try to deport the person, but that doesn't necessarily mean that they're being held accountable for the widespread systematic harm that they committed against communities. Sometimes they're prosecuted in their home country, sometimes they're not. There's also some holes in the other statutes, like jurisdiction over torture or genocide if committed abroad against a US citizen. So those are fixes Congress could make. And then there's some practical challenges to those as well, which I'd be happy to talk more about in Q&A if folks are interested. I already kind of talked about the ones in civil jurisdiction, how they're not interpreted to apply abroad. And then I listed a few challenges in terms of the other legislative authorities that we have to pursue atrocity prevention, such as resources, funding, staff, political support, popular support, and then access and leverage to the situation country or perpetrator in terms of the US trying to effectuate an atrocity prevention strategy that it creates. It matters what our relationship is with that country and whether they're receptive to criticism or sanctions or all those things. So here's just so you have an idea of the web of different groups and actors that advance atrocity prevention and accountability. There's lots of places within the US government that do this. Obviously, Congress, I've talked about the executive branch and their atrocity prevention work. There's other governments. Victims groups have been really important in terms of both advocating to strengthen US law on atrocity prevention, and then and also encouraging the US or other governments to pursue action through the United Nations, for example. International courts, of course, play an important role, and one that we follow closely as lawyers and engage with. But there's also lots of other groups too, like regional organizations such as the African Union or Inter-American System. Lawyers, religious and community leaders, journalists are really important in terms of documenting crimes and ensuring that the true nature and systematic nature of atrocity crimes are reflected in policies and that people know kind of the extent of what's happening in these situations. And then civil society, of course, in all its forms, are really important advocates. And then nearing the end, but I pulled an example from a white paper written by Dr. Beth Munskak, who's now the ambassador at large for war crimes, but she wrote this before she held that position when she was working as an academic. But just here are some of the examples of the kind of range of policy tools that the US uses to advance atrocity prevention and accountability, just to give you an idea of all the different levers that could possibly be pulled depending on what would resonate best in the situation, or what, you know, victims groups think would be make the biggest difference, or what they need, you know, responding to their needs or the specific crimes. So you can see it gives there's a lot that could be done in order to create kind of holistic and responsive atrocity prevention and accountability strategies. And then lastly, just to kind of maybe keep the conversation going, you know, why do atrocity crimes matter? They often occur abroad. The impact is maybe less directly felt, but here are some reasons why they matter, you know, to various groups. In terms of prevention, atrocity prevention protects human dignity and life. Of course, that's kind of the moral obligation in terms of advancing prevention and accountability for these crimes. Protects international peace and security. You know, we know that atrocities often devolve into full-blown armed conflicts that have international consequences, as we've seen with the war in Ukraine, for example. So the ripple effect is quite large. And then that leads, you know, another one is prevention is less costly than the response. So if that is a motivating factor, then focusing more on prevention is effective. And another one I think that the US has been interesting in the US is the kind of focus on more upstream prevention, which means, you know, starting from individual human rights violations and their progression to full-blown atrocities, can perhaps encourage more creative, strategic, holistic policies rather than responding to an acute crisis when it happens. And then lastly, there's legal obligations to do it. As a lawyer, you know, with the Genocide Convention has obligated states, including the United States, because we're a signatory, to prevent and punish crimes of genocide. The Geneva Conventions do that for war crimes. There isn't a Crimes Against Humanity Convention currently, although there's one being negotiated through a UN and International Law Commission process. So happy to talk about that more if you're interested. But the kind of the legal obligations on these crimes are quite significant. And then I'm sure this group is familiar with the benefits of accountability. There's a multitude. It creates a truth and a historical record of what happened in these situations. The appropriate, you know, charging things as atrocity crimes can have a big impact for not only creating that record, but just for the victims of the crimes themselves to have what happened to them be recognized as, you know, a systematic policy of attacking civilians versus an individual bad actor, for example, who committed a murder. So that's really important in terms of, you know, having the crimes be recognized and hopefully preventing them from happening again. And then revealing the root causes of conflict, like discrimination, obviously empowering victims to engage and drive in those accountability processes. And then also specifically, sometimes it's required in order to pursue reparations for harm that victims are recognized as victims. And then again, there's legal obligations to do it. So that's kind of an overview of what I was thinking of why these matter. And I hope we can keep talking about that in Q&A. Thank you.
Great. Thank you so much, Kristin, for that wonderful background and giving us some ideas on sort of what is happening so far, where people can get a purchase on these things, on fighting against atrocity. I think we have a few questions, but I think we'll hold off on answering them until Esti has had a chance to talk about the ICC and how the US is and isn't supporting the current challenges that exist. And so after Esti presents then we'll come back for some Q&A together.
Great. Thank you so much, Amanda. And thank you, Kristin, for that great presentation. I feel like I learned a lot, and I want a copy of that easy snapshot of all the atrocity crimes. I'm going to put it next to my desk, so I have a cheat sheet. It's really helpful. Thank you also to the sponsors and all of the attendees here today for their interest. And like Kristin, I'm speaking in my personal capacity today, not on behalf of Human Rights Watch. So I'll be taking a little bit of a deeper dive into one of the international courts that Kristin has mentioned, the International Criminal Court, and the sort of US policy and how it's evolved over time. In terms of the history and background, as I'm sure many of you know, the US has really been a strong supporter of international justice for a long time, since Nuremberg all the way through the ad hoc tribunals that concern the former Yugoslavia and Rwanda. And yet the US government has had a long-standing objection to the ICC because of its potential jurisdiction over nationals from non-member countries, which could potentially apply to US citizens. So the US was one of only 7 countries that voted against the Rome Statute, the court's founding treaty, when it was adopted in 1998. The Bush administration was initially very hostile toward the court, although later it didn't veto a UN Security Council resolution asking the ICC prosecutor to investigate crimes in Darfur, Sudan. Then the Obama administration took a much more constructive approach, and while his administration didn't wholeheartedly embrace the court, they basically took a case-by-case approach where they cooperated with the ICC based on specific investigations. Then the Trump administration took a very aggressive course, culminating with the issuance of sanctions against the then prosecutor. Now, since the Biden administration came on, they've removed those sanctions, and they publicly stated that they've reset the policy toward the ICC. Now, how has this reflected in terms of Congress? On the congressional side, that objection that I mentioned at the outset really has translated into legislative restrictions that have really limited cooperation with the ICC for the last 2 decades. One of those is what's called the American Service Members Protection Act, which has significant restrictions on providing material support to the court. And famously, it's been nicknamed the Hague Invasion Act because there's a provision in there that will allow US forces to invade the Hague in the Netherlands to release any American citizens held by the court. There's a separate legislation called the Foreign Relations Authorization Act, which also prohibits any funding to the ICC. Some of those restrictions were loosened by the Dodd Amendment, which now enables and allows support to the ICC in specific cases when a foreign national is accused of an atrocity crime. Well, things have changed a little bit, and since the last Congress, or pretty significantly at least, in light of the unprecedented support for accountability as a result of the Ukraine conflict, there have been a lot of new proponents of the ICC, including some previously vocal opponents of the court, including Lindsey Graham. And so as a result of all of that, just on the eve of the holidays in 2022, last day of Congress, and after President Zelensky visited Congress, Congress passed and loosened some further restrictions on cooperation with the ICC. So I'll touch base very briefly on those and happy to elaborate further in the Q&A. So now the ICC, can conduct what's called investigative activities related to the Ukraine situation in the US. So before that, if the ICC identified a potential witness or victim that was in the US, they couldn't come here to interview them. Now they can, so long as it's related to Ukraine. Second, the US can now assist the ICC's Ukraine investigations and prosecutions, including supporting victims and witnesses, even if there's not a specific individual that's been accused of a serious crime. And again, this is specific to Ukraine. Third, now the US could provide financial and in-kind contributions to the court, including its trust fund for victims, but this is unfunded. So if the Biden administration or Congress really wanted to give meat to that provision, it would need to appropriate funds to do so. So that's great. There's new legislative flexibility and authority to cooperate with the ICC, but that doesn't necessarily mean that the Biden administration is going to use or is using that authority to exercise its flexibility. So now I'll touch briefly on something that may interest many of you, which is sort of the Ukraine effect and how is the US actually cooperating with the ICC's investigation in Ukraine. So the Ukraine conflict has really put the US between a rock and a hard place. On the one hand, it's been very vocal about the fact that it wants accountability for atrocities committed in Ukraine. But on the other hand, this is a situation that involves two non-member countries. Both Russia and Ukraine are not members of the court. So it really puts at heart the US objection over ICC's jurisdiction over nationals of non-member countries. Initially, when the conflict first expanded last year, the US referred to supporting all accountability mechanisms for justice in Ukraine, but it tended to bend over backwards and avoiding specific references to the ICC. Slowly but surely, the language sort of evolved, and now the US has said that it supports all investigations, including the ICC's. But really the question has meant, what does the support really mean? There's also been quite a bit of a rapprochement between the US and the ICC. There's been a lot of high-level visits between ICC officials as well as US government officials, including high-level delegation, congressional delegation that visited the court. And that was unprecedented, something that had never happened before. So as I mentioned, the question is, what does support actually really mean? And what we've found out is that notwithstanding the fact that Congress has provided legislative authority for the Biden administration to cooperate with the ICC, that's actually not really happening. There's been public reporting of an internal policy debate within the Biden administration as to whether or not to provide tangible evidence to the ICC. And as it turns out, it sounds like the Department of Defense, the Pentagon, is to blame. That is very much sort of the bad apple here. And again, Lindsey Graham has really been very vocal in blaming the Department of Defense. So last month, the ICC's judges issued arrest warrants for Vladimir Putin, the president of the Russian Federation, and Maria Lvova-Belova, the commissioner for children's rights in the office of the president of the Russian Federation. The judges confirmed that there are reasonable grounds to believe that they both bear criminal responsibility for the unlawful deportation and transfer of Ukrainian children from occupied areas in Ukraine to the Russian Federation. So really, this has put the issue of ICC or US cooperation with the ICC's investigation really front and center. The Biden administration, there's been several reactions coming out. President Biden told reporters that he believed that the issuance of the arrest warrants were justified and made a very strong point. And Senator Graham went even further and issued a press release and said that the warrants are more than justified based on the evidence. And he said that the Department of Defense reluctance to share information and evidence with the ICC is undercutting our efforts to hold Putin accountable. As a result, a few weeks ago, several US senators wrote a letter to President Biden urging him to use the legislative authority that they had given him and begin cooperating with the ICC. So what's the impact of all of this? Well, there have been several high-level multilateral diplomatic conferences on accountability recently that the US has attended, where we have, a lot of US allies attending that are rallying behind the court and providing support for the court, resources and the like. And it's becoming increasingly, I would say, awkward and difficult for the US to say with a straight face, well, we really support accountability in Ukraine, but we're not going to provide tangible assistance or evidence to the ICC, even though there's apparently information that is relevant to the ICC's investigation. Separately, it's kind of ironic, but the Russian Federation has now criticized the ICC and its issuance of arrest warrants by parroting the US argument and saying that the arrest warrants are invalid because Russia is not a member of the court. So they're using the US argument against, against accountability. And then this morning, there was actually a hearing in the Senate, which again, there was broad bipartisan discontent over the Department of Defense blocking the implementation of this recent law. Graham apparently went on again to say that the Department of Justice has been great, but the Department of Defense has been terrible. And I never really thought I would see the day where, Senator Graham became such a vocal proponent of the ICC. Maybe I leave, there's definitely, we would have, some recommendations on how the legislation could be, improve the current legislation, but perhaps I can leave that for the Q&A, as well as how this is affecting, cooperation with respect to other situations.
Great, thank you so much, Esti, for that orientation. I appreciate the a better understanding of how the Biden administration is supporting or not necessarily supporting the ICC. We have a couple of questions in the chat, and so I was thinking I have a question for each of you based on those questions that we'll start with. But for those of you who still have questions, please feel free to put them into the Q&A, and we'll try and get to them as soon as we can. Esti, I think we'll start with your question first, just since you were the one who was just speaking. And I think the question that we have here is from one of our participants who is a refugee from a Rohingya refugee from Bangladesh. And he's wondering how the US can support accountability for crimes committed against the Rohingya. And I think too, just generally speaking, and hearing you talk about the ICC, a related question is what we can do to support the Biden administration or the who should we be supporting to try and avail themselves of the new flexibility that the Biden administration has created to participate with the ICC investigations. So relative to the Rohingya situation, and maybe more generally, if you could answer that.
I mean, as you said, the ICC has many important investigations underway that implicate nationals of non-states parties, and that includes Myanmar and includes Georgia. The US has not publicly voiced its support for either of those investigations because of that ongoing policy objection. And obviously that would prevent active cooperation with any investigation or arrests. And we would say that that highlights an issue of inconsistency and double standards, and that US legislation should be really broadened to cover all situations and not be only Ukraine specific. And again, that the US should be setting aside its objection so that it can help bring justice to victims wherever the crimes are committed, and regardless of by whom the crimes are committed. So specifically on the Myanmar situation, as you just mentioned in the chat, the US government has made the determination that genocide and crimes against humanity have occurred. It's certainly cooperating with the investigation that is being conducted by the IIIM, the investigative fact-finding mission, but it is not cooperating, at least as far as we know, with the ICC's investigation because of that objection that I mentioned before. And also one of the little inside baseball points in terms of the legislation, as I mentioned at the outset, that the legislation provides that the US can cooperate with an investigation if there is an individual who is accused of an atrocity crime. And that we understand has meant that there's some kind of accusation that is required. That's at least how the Department of Justice has interpreted it. And it's unclear what kind of accusation is required. Does that mean an arrest warrant? And if that's the case, well, certainly in Myanmar, there has not been yet any public arrest warrants, at least as far as we know. There could be sealed arrest warrants. And so that would be sort of a second barrier beyond the policy objection that would make it difficult for the US to cooperate. And if I could just briefly touch on two other situations which we think, again, merit US support. Georgia, for example, again, involves nationals of non-member countries, including potentially Russian nationals. There have been 3 arrest warrants that have been issued by the ICC. And so that's an instance where this sort of accused of obstacle is not present, but the policy objection is present. And so again, this would prevent the US from cooperating with trying to identify and arrest those individuals. I'll also mention that with respect to the Darfur Sudan situation, this was a situation where the US has allowed the referral of the investigation to the prosecutor. And we know that the US has really proactively shared evidence with the court. And to answer your question briefly, Amanda, in terms of, who should we be pressing, so to speak? As I mentioned, it seems like the Department of Defense is really kind of preventing cooperation with the ICC based on the longstanding objection. So it's a matter of trying to change their minds, but unlikely for that to happen. So it should certainly be an internal policy debate. And I think Congress is really playing an important oversight role here, including in that letter that I mentioned, in these hearings where they're asking the Biden administration, what are you doing with the legislative authority that we've given you? And then the hope would be that, President Biden has the authority to basically overrule the DOD objection. The question is whether he's going to really want to do that, leading up to a potential presidential election next year.
Thank you.
Amanda, if I could add something on, I thought the question on the, accountability for crimes against the Rohingya, that situation for me is really illustrative of, number one, the limits of international justice and accountability, but also the opportunities. Esti talked about the ICC case specifically. There's kind of also some other efforts going to seek accountability for those crimes, partly because the ICC's jurisdiction is limited in that situation, because Myanmar is not a state party, so they have jurisdiction over the crime of deportation and maybe connected crimes, but it's kind of a novel legal situation for them. So I just wanted to highlight in terms of other kind of paths to accountability. There's an International Court of Justice case where the Gambia is suing Myanmar for violating the Genocide Convention by allowing or perpetrating a genocide against the Rohingya. So that's really interesting, and states might be supporting that case in some way. I think some states have, intervention is possible. I know they've done that in the Ukraine situation. Maybe not all states want to do that, but just following the case and supporting the Gambia in its effort to pursue that is important, because the International Court of Justice determines state responsibility for violations of international law. So in this case, it's state responsibility for violating the Genocide Convention. But because the government's involvement and the military's involvement in the crimes, that also really gets to who's most responsible. So that while the International Criminal Court adjudicates individual criminal responsibility for crimes, the state responsibility is just another aspect. So that case is really interesting and will be great to follow. There's also efforts to highlight those crimes in national courts. So, I was talking about the United States' domestic law on atrocity crimes and how there's some limits there. Other countries have those crimes in their laws and maybe have less restrictions. So Argentina is an example. And I think a Rohingya group is pursuing a case in Argentina against individual perpetrators for crimes committed against the Rohingya, and courts in that country already have taken the case and are working to kind of include testimony and move it forward. So that's another just interesting way that justice is pursued internationally. I think groups have also submitted information to some national governments in Europe about crimes against the Rohingya and also post-coup crimes in Myanmar. So, just an example of how justice can be pursued in lots of other forums. And I know the United States is certainly aware of those from what I've heard, and is, might be supporting them in some way, but they might not necessarily be public about how they're supporting them. But it's just interesting to see kind of like I said, the different paths that justice can take.
Thank you, Kristin, and for orienting us to the fact that there are these multiple different channels through which people can create change and advocate for fighting against atrocity crimes. Along those lines, we have a couple of questions about both the movement to whether it was you in your talk, you mentioned that there was new legislation pending about crimes against humanity, trying to create a definition for what that would consist of. And there's a question in the chat that's specific to is there a movement in the US? I don't remember now if you said that this pending legislation was US led or something that was internationally led. But to fight crimes against humanity. And is there general bipartisan support for atrocity prevention as well? Lindsey Graham aside, perhaps.
Yeah, I'll take that. And just before I forget too, one other thing on the last question is, in addition to those formal justice processes, I think there are other things the US could be doing. We talked about the trust fund for victims. Another thing might be like specific, depending on what's needed in order to pursue justice, there might be other specific issues like witness protection or supporting, evidence collection. I think a lot of that has already been done in the Myanmar situation, but just to keep in mind, in addition to kind of the formal, taking cases to court, there's lots of other things that the US does in terms of policy that could be pushed upon depending on what would be most helpful and what's really needed in a particular situation. So on crimes against humanity, there is an effort. There's actually been quite a long-standing effort. Domestic law on crimes against humanity was first introduced in 2009, I believe. It was kind of broad, but it didn't move through to a vote. There was an agreement on the particular text that was introduced. I know human rights groups had certain objections in terms of what acts were included. I think, different entities within the government had certain reservations as well, but that at least is out there as a past effort. I think it was revived a little bit in 2016, but we didn't get an actual bill. And we're in the same situation now. There is, I would say, significant interest. Senator Durbin led that 2009 bill, and he has been a proponent of addressing the loophole on crimes against humanity for quite some time. And so he has raised it in hearings. There was just one this morning in the Senate Judiciary Committee about Ukraine, where the representative from the Department of Justice raised the lack of crimes against humanity statute and how and encouraged Congress to consider passing something because of, it would give the department another tool in their toolbox to pursue perpetrators of these crimes, especially when they're in the US, but there's also other circumstances like when crimes are committed against an American victim, for example. That's something in which the US would have a really strong interest in seeing accountability. So, I think it's been raised more publicly in the past 2 years. Last year, it was part of the debate about in terms of the war crimes bill that I talked about, the Justice for Victims of War Crimes Act, but crimes against humanity wasn't included when the bill was actually introduced. I think it seemed like more discussion was needed in order to build bipartisan support on that particular issue. And obviously the war crimes part was successful. So that's very encouraging in terms of willingness to fill that gap domestically. So I would say stay tuned. There has been much more public discussion about the need for a crimes against humanity statute, both from particular members of Congress, but also within the administration with these past hearings. And I, for one, of course, hope that a bill would be introduced, but we'll see. and just in terms of the bipartisan support, we do have these good precedents on the War Crimes Act most recently, but also I would highlight again the Elie Wiesel Genocide and Atrocities Prevention Act, because that was bipartisan. And so, groups have been advocating, for example, for Congress to really keep its oversight role on that bill, and in terms of, engaging with the administration and what they're doing to implement it and make sure that that what they're doing is living up to what's required under the law in terms of pursuing strategies and identifying gaps in their own capabilities. So that was a bipartisan bill, obviously, and I think at least provides a good foundation for pursuing additional legislation on a bipartisan matter.
Great, thank you so much. And I know, Esti, we have a question for you, but I want to follow up, Kristin, with one more question. And that was Nancy in the chat was asking if there's a specific example in the US of a case where a specific person was prosecuted due to US laws, or if that's something that's just reserved for potentiality.
Yeah, great question. There has not been a prosecution for war crimes or genocide. The only one that has been used is the torture statute. So there have been 4 people charged with torture. One of them was deported before he could actually be prosecuted. There's been 1 successful conviction so far. And that was, I'm gonna say Chucky Taylor. Anyways, it was for, yeah, one conviction for torture for crimes committed abroad. But the US has also in the past few years included charges in 2 more cases. So that one has been used and is obviously a blueprint for how when you have the right law that includes jurisdiction, needed over people who are present here, for example, that it can be used successfully. There's still a lot of challenges in terms of, obviously you need custody of the perpetrator. So when somebody's present in the United States, that's easier than when you have to, request their extradition abroad, for example. But so custody, access to the evidence, proving atrocity crimes, although very important to recognize them as atrocities, is difficult because you need significant evidence, not just, usually not just of a crime against one person, but of a widespread, for crimes against humanity, at least widespread or systematic attack against civilians. So in some cases that information is readily available and public, but it's not always as easy to tie it to a specific person and their role in the atrocities. So there's, and then the statute of limitations is also a problem and a challenge. So yeah, there's encouraging efforts. There have been prosecutions for torture, not on these other substantive crimes, but some of those barriers have been removed now through the Justice for Victims of War Crimes Act. So hopefully we'll see more in the future.
Thank you. Thanks so much, Kristin. Esti, I have a question here for you around what you think the top motivators are for the changed U.S. attitude to the ICC over the Ukraine war, looking for similar motivators that civil society could try to leverage for more attention in other situations.
Yeah, thank you for that question. We've certainly been thinking about, the opportunities that the Ukraine conflict and sort of this rallying around accountability for Ukraine and how we can try to replicate that to other situations. I mean, I think there are some very specific motivators. First off, this is happening in Europe's backyard. It's the first time since World War II or since the former Yugoslavia conflict where there is such a conflict so close to Europe. And then obviously sort of the Russian geopolitics, I think, are at play. And so what we've seen, not just from the US, but from others as well, is this desire to just be seen as doing something, even if justice may seem so difficult to achieve. But we've been trying to highlight at Human Rights Watch the dangers of selective justice and really saying that the justice response that has been happening around Ukraine needs to be replicated to other situations. I mean, we've seen that the ICC prosecutor asked for an increase in resources that wasn't necessarily tied to Ukraine specifically, but very much in the context of the Ukraine conflict. And, European states have, just thrown a lot of money at the problem. And we've tried to highlight that, all victims deserve justice and access to justice. And one situation and one case should not be prioritized necessarily over others, especially when it has, some racial undertones. So we're really trying to push that message across, and I think really highlighting in your advocacy the need that all victims are equally deserving of justice is really important.
Thank you so much, Esti. And I think this might be our last question, and it's maybe an opportunity for Esti to speak specifically about this notion of selective justice and how to guard against it in larger contexts. And maybe, Kristin, you can also weigh in on this. Nancy in the chat is asking that the U.S. response to atrocity crimes differs depending on the U.S. relationship to that country. Are there examples in other countries where they have created laws that requires equitable responses regardless of the country's relationship with the other country? If not, do you have recommendations for how this could happen? So maybe you could both address this question in whatever way makes sense in your context, and then we can wrap up afterwards. Is my question not clear? No one's jumping in. Kristin.
You want to go ahead, Kristin?
It's just a big question. Yeah, and I can't speak to other countries' laws necessarily and their examples. I do. One thing I've thought is interesting in terms of watching the atrocity prevention field progress is that I talked about kind of the U.S. institutionalizing atrocity prevention within government. But there are other countries are doing similar things. There's a global coalition, the acronym is GAMAC, GAMAAC. And so they have some interesting information about like national units on atrocity prevention and accountability. For example, I know the UK has had a lot of discussions in terms of its own internal atrocity prevention policies and architecture as well. But yeah, I mean, from my perspective, the positive thing about institutionalizing atrocity prevention this way is that hopefully it would increase the consistency of US responses. It doesn't mean that the US should have the same response necessarily in each situation, because the situation might require different solutions. And what I meant by saying that, it depends on the country is that obviously the political relationship the US has with a country really impacts its response in terms of like whether they're using a carrot or a stick, for example, sanctioning the perpetrators, calling for ceasefires, or like encouraging negotiations to end a conflict before, moving to a transitional justice discussion, for example. So it really depends on the situation and what levers are going to be most effective. But yeah, I think in institutionalizing that process and kind of I hope that we're building an understanding of the different tools that are out there. And so that the expectation will be built that there is some kind of response, there is accountability in a certain situation. And the question then more moves to how, rather than if.
Great, thank you, Kristin. Esti, I want to give you a chance to answer that too, so please.
Yeah, sure. Very briefly, just to say that there are several jurisdictions, especially in Europe, that have what's so-called universal jurisdiction laws on their books, which means that they can bring prosecutions of atrocity crimes regardless of the nationality of the perpetrator or the victim. And so they are much more progressive in that respect. And as Kristin mentioned, there's several of those countries that have national war crimes units where prosecutors are really dedicated, and have the resources to go and investigate those crimes. And notably, there's been an important case last year in Germany that convicted a Syrian leader for torture. and as well as some cases in Switzerland. And just yesterday, there was an announcement that the minister, I believe it's the Minister of Interior of Gambia, is going to be brought to justice in Switzerland. So those are really important cases, and certainly around the discussion on the new revised War Crimes Act. And I think it was put in the chat a Lawfare article that I had written. One of the things that we pointed out was that the US is has fallen behind some of its European allies in terms of its ability to bring domestic prosecutions for these crimes. And certainly the first step of this new Justice for War Crimes, Victims of War Crimes Act is kind of getting us in line into that. And I think just as Kristin has mentioned, the next step is really criminalizing crimes against humanity so that we can sort of pick up the pace a little bit.
Great. Thank you so much. Thank you both for taking time with us today, and thanks participants for being here. Before we close, however, I want to just thank everyone for coming and taking this issue to heart. And we hope that you'll join us at our next discussion, which is on April 26th at 12 p.m., Confronting the Empire of Silence, examining various ways Congolese communities are seeking justice by collecting testimonies, creating ad hoc truth and reconciliation initiatives, and sustained advocacy at the local and international level. But also, please look that tomorrow we have a special program that our partner Lauren Fortgang is in Washington, D.C. Offering this program tomorrow. It marks the 20-year genocide commemoration in the Darfur region of Sudan, and the Never Again Coalition is co-hosting a panel discussion on the legacy of atrocities in Darfur in the context of the violence that has broken out between paramilitary forces and the military in Sudan in recent days. So the discussion can be viewed online tomorrow at 11 a.m. Pacific time, and I believe there's a link in the chat which will give you access to that. We also want to update you that we have had to cancel the final program of the Rising Up for Human Dignity series, which was planned to take place on April 30th. We will be rescheduling that for this fall. And if you purchased a ticket, you should already have been refunded for that. And we're sorry for any inconvenience that has caused. So to conclude today, I want to thank Kristin and Esti and everyone who joined us today, and all of the partner organizations that have worked with us over these many years to create this Rising Up for Human Dignity series in honor of Genocide and Atrocity Prevention and Commemoration Month in April, where we have the opportunity to bring these conversations to our community. So if anyone has any closing remarks, this would be your chance to do it. There's 30 seconds for any last Q&A questions that may be coming out. Please do note that the chat has lots of excellent resources and links. This program has been recorded and will be available to you if you want to rewatch any of it or access any of the information. So thank you all for being present, and thank you again to our wonderful panelists.
Wonderful. Thanks so much. And thank you for your wonderful, thoughtful questions, everyone. Really appreciated the discussion today.
Great. Hopefully we'll see you all at the event on Sudan tomorrow. So thank you.
Bye.